Welcome back to This Week in Immigration. I'm your host, Hanadi Jordan, Communications Coordinator at the Bipartisan Policy Center. Joining us today is BPC Director of the Economic Policy Program, Rachel Snyderman, and BPC Senior Advisor and This Week regular, Theresa Cardinal Brown, to discuss President Biden's move to expand portions of the border wall. We'll dive into the appropriations process, what it entails, and what happens after Congress appropriates money. Then, Theresa will walk us through the recent settlement between the Biden administration and the ACLU in a class action lawsuit against ICE over the separation of children and their parents at the southwest border under the Trump administration's zero tolerance policy. We've got lots to discuss today, so don't go anywhere. In a compromise back in 2019 to fund the government, Congress agreed to appropriate $1.4 billion for the border wall. Despite his campaign pledge to build not 1 foot of the wall, President Biden announced on October 5th that he would build out a section of the border wall up to 20 miles. He defended the decision by stating that he was legally obligated to do so as a result of the way that the money was appropriated back in 2019. It's getting a lot of grief from the left, Democrats, border folks, and immigration advocates for this. Joining us now to dive into the issue is Rachel Snyderman and Theresa Cardinal Brown. Rachel and Theresa, thank you so much for joining us today.
Thank you, Hanadi. It's great to be here. And likewise, Theresa.
Thanks, and great to have you, Rachel.
So, first, let's start off by going back to 2019. Theresa, can you tell us how this deal came to be and what the appropriations for the wall entailed?
So let's go back in the Wayback Machine, although not that far back for some of us. People will remember that President Trump ran on building a great big beautiful wall along the U.S.-Mexico border. He had campaigned that Mexico would pay for the wall. But when he was elected and tried to build the wall, Mexico said, absolutely not, we will not pay for it. So he had to go to Congress and ask for the money to build the wall. At the end of 2018, as the Congress was trying to fund the government, President Trump initiated essentially a government shutdown by refusing to sign legislation unless it included funding for his border wall. In the end, he did not get the funding, all the funding from Congress. He wanted $25 billion. He reopened the government in part because he was given to understand by members of his White House staff that he could declare an emergency and basically take the money from other parts of the government, which is what he ultimately did. However, when the fiscal year 2019 final appropriations bill was passed, there was, as you mentioned, about $1.4 billion for various parts of the border wall, including specifically for border wall in the Rio Grande Valley of Texas. And so that money, by the terms of the appropriation bill, was available until September 30th, 2023. So it had to be used within that time.
Now, Rachel, there was a lot of questions about whether Biden was indeed legally obligated to spend this money. I think Theresa just touched on that. But can you give our listeners an overview of the appropriations process, how money is spent after it's appropriated, and whether Biden was indeed legally obligated by the 2019 appropriations to spend that money?
Of course. So I do think that when we look closely at the appropriations language, we can see that there's explicit language that says that the funding as appropriated is for the construction of a barrier system along the southwest border. That makes it really clear that the money, as directed by Congress, this is really emphasizing the beauty of the checks and balances in our government, but also that Congress has the power of the purse. Congress has the authority to appropriate dollars, and then the executive branch has the responsibility to execute on that appropriation. And so when we're kind of taking a step back and looking at where this fits in within the broader appropriations and budget process, I think Theresa made a really excellent point of kind of framing how the entire budget and appropriations process comes together, especially when it surrounds a president's policy priorities. So the budget process kind of kicks off when the president submits their formal budget request to Congress each February. And as President Trump did that year, funding for the border wall was included. Now, Congress doesn't necessarily have to listen to every single budget priority of every administration. And in fact, but the president's budget each year has become really an outline of an administration's policy priorities, much less than actual final appropriations that then get passed into law by Congress. But it serves as a really important signaling device. And at this time, there was congressional support for appropriating dollars directed towards funding construction at the southwest border. And so that's what Congress did. Now, traditionally, that process of the deliberation of, we're really talking about the discretionary funding here. So that funding that Congress allocates and negotiates on each fiscal year. So it must do by September 30th of each year before the start of the fiscal year on October 1st. Congress traditionally has to, both chambers need to pass 12 appropriations bills and get that legislation to the president to sign. Doesn't always happen on time. That's why we have things called continuing resolutions, or even worse, government shutdowns. But the important kind of part, and the reason why I want to emphasize this, is that this was really a demonstration of kind of where the president's policy priorities got implemented into law, and then what comes next. And so after the appropriations process finalizes in either a continuing resolution or a full year appropriations bill, then the power swings back to the executive branch. The Office of Management and Budget is an agency within the executive office of the president that oversees the apportionment of funds. So think of kind of the appropriations process establishing budget authority for agencies. Now, there's many different forms of budget authority, and we can get into the wonky, budget process language. But for the context of this discussion, if we're just focusing on appropriations, we're thinking about this as the agency's spending limit, which authorizes the obligations and outlays that an agency can incur. And so over at OMB, they're really tasked with kind of outlining the spend plan, a legally binding document that helps an agency understand by when and where it can allocate those funds. So at this current point in time, we're looking at Customs and Border Protection really having to assess their spend plan for how they were going to implement and allocate funding for the border construction as it was appropriated in fiscal year 2019 through the remaining fiscal years. And happy to dive into a few of the additional wonky budget terms as we progress in our conversation.
I'm curious, Rachel, generally, are there any penalties or repercussions for not spending appropriated money? Like if, let's say in this case, if Biden were not to have spent that money, what would have happened?
So it's an excellent question. And the Impoundment Control Act of 1974 really provides the mechanism through which, or it establishes the procedures, if you will, that prevent the president or other government officials from basically unilaterally dictating their own policy priorities in place of those that Congress has enacted into law. So, for example, President Biden, because of the Impoundment Control Act, President Biden could not reprogram or rescind the money that was appropriated specifically for the purpose of constructing the border wall, just because it did not align with his administration. That would be a violation of the Impoundment Control Act, and is actually something that we've seen come up in past debates. In July of 2019, for example, this became an issue when there was discussion over potentially withholding international security assistance funding for Ukraine. And so it's a very specific law that outlines that an administration or a president cannot unilaterally, for their own policy priorities, change or dictate what Congress has otherwise said must be approved.
Now, outside of the Impoundment Control Act, is there anything that would prevent a president from not spending appropriated money?
So when we look to the apportionment process, if you will, there are, and again, these are legally binding documents that agencies submit and are approved by the Office of Management and Budget. These really are spend plans that agencies have to work with OMB to be able to spend down. So I think that In this context in particular, there are many different kind of categories that we think of budget authority or there are different categories. The budget authority can be obligated and then outlaid or spent. So, for example, funds that are appropriated can be apportioned by time, so by the duration of whether or not those are single fiscal years, multi fiscal years, or if there's no, they can just be spent until expended, or they can also be apportioned by a specific program or activity, such as, for example, the construction of a border wall. There can also be a combination of both kind of the time limitation and that program activity. And so it's kind of within that context of the apportionment process. Again, this legally binding document that helps agencies really understand and spend down their budget authority as appropriated by Congress. That really does provide that outline. Now, if an agency, for example, does not spend to that plan, they could potentially be committing a violation of the Anti-Deficiency Act, which is another law that helps dictate budget process and the apportionment process as well. So I know I'm introducing many different kind of laws, but these are the kind of the safeguards, if you will, that really do help protect kind of the appropriations process and also those policies that Congress has put into place that are meant to transcend administrations.
So, Teresa, this decision is getting a lot of flack, as I mentioned, from the left. And I'm curious if you can just give us an overview of sort of the criticism Biden is garnering from immigration advocates. What are they saying? And how has the administration responded?
Yeah, so as Rachel said, obviously President Biden ran on not building any border wall. And so this is seen first and foremost from a political standpoint as going back on a campaign promise.
Yeah.
The fact that the administration's hands were somewhat tied because of the way the law was passed in 2019. And as Rachel mentioned, they tried to get Congress to move the money, to allow them to use the money for something else or rescind the money. Congress can take back money it's appropriated through a process called rescission, or rescind the money, and Congress did not do that. So, and by the way, this is true when Biden had Democrats in charge of the House and the Senate as well. They did not do that. So since it was not done, and he, basically ran out of time because this money had to be spent by September 30th this year, he went ahead and moved. I think that one of the reasons that the immigration world and frankly many people who live along the border who are not happy with border wall construction in general was that the way it was done. So the Homeland Security Act and some other Secure Fence Act and some other laws passed by Congress allows the Department of Homeland Security to waive a lot of other laws that usually come into play whenever the government wants to build something. Things like the National Environmental Protection Act, or NEPA, requires you to do an environmental impact assessment. What would the environmental repercussions of doing this thing be? They have to look at what other would it impact small businesses in the area, just a lot of reviews and other things. The Endangered Species Act, will this interfere with an endangered species? So there's like 20 laws that can implicate any kind of construction activity that a federal government wants to do. But Congress specifically authorized the waiver of all of those laws for border construction. So Biden had tried not to do that. They had entered into some sorts of like localized consultations and things like that. But at the end of the day, to obligate the money, which means I promised to spend it, I've signed contracts, he had to waive all of those things to move forward with the building of the wall. So one is sort of the objection that why is Biden building wall when he ran against it? And many people just oppose building of the wall in general. But two was the waiver of all of these environmental laws to achieve it. And I think Biden kind of made clear a little bit that he knew this was not something he wanted to do, because when he talked about it in a press conference, he said, no, walls don't work, but I had to do it. Right. So He recognized that Congress had its, as Rachel said, its policy priorities that were put in law. They didn't change it when he requested them to do so. So he didn't really have an option. That having been said, that doesn't make opponents of the wall any happier that more wall is getting
Yeah.
built.
Yeah. I mean, I think you and Rachel have pretty well established that Biden's hands were tied in this situation, but I'm curious if there are alternative approaches the administration is taking right now to address border security specifically.
Well, the answer to that is yes. And if you've been paying attention on this podcast and other places, they've been trying out a lot of new policies to try to address what has been a record number of encounters at the border. So the end of the fiscal year was September 30th, 2023. Customs and Border Protection just this past weekend released its final end of the year numbers of encounters. And if you include everybody at the port of entry and between the port of entry at the southwest border, this is a record breaking year. Interestingly, no, between those two places was a difference. So Border Patrol actually saw a little bit fewer encounters than last year, but more people are applying at ports of entry. And that's a result of some of the policies Biden has put in place, like the CBP One app, which allows people to apply for an appointment to go ask for asylum at a port of entry. The new parole programs for Cuba, Haiti, Nicaragua, Venezuela, also Ukraine, have meant that more people are arriving at a port of entry with a parole than previously. So there is a little bit of a shift in where people are arriving, but the numbers are still very, very high.
Well, we also know that Biden recently requested $14 billion in supplemental funding for the border from Congress. Can you talk a little bit about that and what sort of the strategy behind using that money would look like?
Yeah, so this is a supplemental request that the Biden administration sent to Capitol Hill again just this past weekend. Let's remember we're on a continuing resolution that expires November 17th. So unless Congress enacts a full year appropriation or another continuing resolution, the government will have to shut down. This supplemental is saying, look, in addition to whatever else you're considering doing by November 17th, we need more money for a bunch of things. So several things have happened since the continuing resolution was passed. Certainly the events in Israel and Gaza have changed some calculus. Situation in Ukraine is still ongoing. There's increasing aggressiveness by China in and around the South China Sea, in particular around the island of Taiwan. So the focus of most of this supplemental request has been these major national security, foreign policy, and defense priorities. So funding for Israel, funding for Ukraine, and funding for defense postures in the South China Sea. As well, and in the rubric of national security, they have added a request for $14 billion for different measures to address all of migration, not just border security, although it's being shorthanded as a border security supplemental. One thing I would note is that $14 billion is about the same amount they're asking for Israel. So that tells you how important and how much money they're asking for. It's the largest amount of money they've asked for all of these things together. But it does include some very important parts of what I would call is Biden's evolving strategy for how to deal with the border. So for example, $1.8 billion would go to Health and Human Services for addressing not just unaccompanied children who have arrived, but also the Cuban and Haitian entrants who are arriving through family paroles and family unification paroles, and for other refugee resettlement populations. So Ukrainians who arrive on Ukrainian parole are also eligible for refugee-like supports when they arrive. There's a large amount, $1.4 billion, to hire immigration judge teams, 375 immigration judges and their support staff for the immigration courts. This is the largest single request that we have seen in a long time. And we all know that the immigration courts are suffering from about a 2 million case backlog. $2.5 billion to immigration and customs enforcement for a lot of things, for additional transportation to arrange for deportation flights for people who don't qualify for asylum, money for new facilities that would be able to house families in a humane way. They're calling family residential centers that would have legal services providers and NGOs there, medical care, education. There's also $4.4 billion for Customs and Border Protection for transportation, holding, and processing migrants encountered at the border, including 1,300 new Border Patrol agents and other personnel to help with the processing. It would reimburse parts of the Department of Defense for active duty military that have been deployed there to help with the arrivals. And very importantly, for the cities that have been asking for federal government support, money for the Federal Emergency Management Agency that would go to the Shelter and Services Program to reimburse them for activities. Another major thing that I would include in here is there is a large amount of funding for the Department of State, some $850 million for humanitarian needs in the Western Hemisphere. Some of this would help countries in the Western Hemisphere address their own asylum systems. There is money in there for helping countries like Panama deport people back from Panama. That's a little bit more controversial, at least from the immigrant rights standpoint. And I would say that, some major funding to address these new safe mobility offices in the Western Hemisphere. So taken together, this is a very large package. But it also represents, I think, as Rachel said, a request that represents a policy focus. And this is pretty clearly laying out what the strategy is for this administration in dealing with the migration in the Western Hemisphere. And at least to my mind, I think they are for the first time accurately saying what it will actually cost to do this.
Yeah. So I have one last question for you, Theresa. As you mentioned, this is about as much money as Biden has asked for Israel, which, highlights how crucial the issue is. If he doesn't get that money, what can we expect to happen?
So, a few different things. I think we will see more people released from the border into the interior of the United States who are asking for asylum. If CBP doesn't get some of this money, if ICE doesn't get some of this money, the only choice the government has really, because with an overwhelming number of people arriving, they don't have the capacity or the people to process them for expedited removal, to do credible fear hearings, to do any sort of expedited process. So people have to be released, and it adds to an ever-growing court backlog. We'd see more of what we're seeing. I think that's the fundamental challenge. Worse if the government shuts down, because that means that only the minimal activities can be done, under what people can reasonably assume is a minimum staffing as well. So I think that it's imperative that Congress should really take a serious look at this. And maybe they disagree with some of these policy requests, but I think they need to recognize that it will cost a lot of money to really address this.
Yeah. Rachel and Theresa, thank you so much for joining us today. We're going to take a quick break, but when we come back, Theresa and I will talk about the recently announced settlement between the Biden administration and the ACLU. Stay tuned. On October 16th, the ACLU announced a settlement with the Biden administration's Department of Justice over the separation of children from their families by the Trump administration between 2017 and 2019. The ACLU filed a class action suit in 2018 seeking to halt the separation of parents and their children at the southwest border. Joining us now to break down the case and the recent settlement agreement is Theresa Cardinal Brown. Theresa, welcome back to the podcast.
Hi, Hanadi. Here we go again.
Yep. So first, before we get into the details of the case and the arguments, can you just give us a brief overview of the family separation policy during the Trump administration?
Sure. So, starting around February of 2017, in some parts of the border, most notably near El Paso, Texas, the Department of Homeland Security began a policy of prosecuting the adult members of families that crossed illegally into the United States to claim asylum. And by doing so, they would take the adults into custody for criminal proceedings and take their children, their minor children, away from them and put them into Health and Human Services custody as unaccompanied children. This was essentially separating families. This was essentially a test pilot by Department of Homeland Security and the Justice Department at that time. The policy was formally announced as something called zero tolerance by then Attorney General Jeff Sessions in May. And what he said was that the United States has a zero tolerance policy for illegal entry to the United States, that everyone who enters illegally will be prosecuted by Justice Department attorneys, because entering illegally between ports of entry is a misdemeanor for a first offense and a felony for a second offense. To give a little bit context to this, the United States government had been prosecuting illegal entries for years at this point, going back in time to, something called Operation Streamline from the Bush administration. But it was not universally applied. It was applied to certain folks, usually on reentry rather than in misdemeanors. So this was a very big escalation and expansion of this policy. But because it resulted in 100% prosecutions, anybody who arrived with a child would be separated from that child. So this began the policy of child separation. And the Trump administration at the time said they believed that this would deter families from crossing into the United States illegally to claim asylum. There was a very large public outcry to this, I think a bipartisan outcry to this. And so in June of 2018, the Trump administration announced the end of this formal policy and that they would try to reunify the families. However, by this time, and actually shortly after the original policy was put in place, lawsuits began on behalf of individuals who had been separated. That became a class action lawsuit. The ACLU was the lead attorney for the plaintiffs in these cases, and that is the lawsuit that was settled this year.
Can you speak more to on whose behalf the lawsuit was filed and what the basis of the legal argument from the ACLU was in this case?
Sure. So the original lawsuit was filed on behalf of a woman who was identified in the lawsuit as Ms. L and her minor child. Ms. L was from Congo. She had come to the United States-Mexico border to try to enter to claim asylum, and she was separated from her minor child. The original lawsuit accused the United States of several things, violating Ms. L's Fifth Amendment right because she was put in criminal proceedings without getting notification of all of her rights in criminal proceedings. There was also a claim under the U.S. immigration laws that she was not allowed to file for asylum, which was her right under immigration law, and the Administrative Procedures Act, in that this policy was put in place without any public notification, without any notice and comment, and that there were no procedures to reunite children who had been separated. So those were the original grounds of the lawsuit.
So interestingly, this litigation started under the Trump administration, but then the Biden administration took it over, had to deal with it, and reached a settlement. Can you speak to how cases like these are dealt with when they're passed between administrations, and how did the case develop as it was passed between the Trump administration to the Biden administration?
Sure. So the initial lawsuit was against Immigration and Customs Enforcement, which is the agency that had Ms. L in custody and referred her for criminal prosecution, as well as Department of Homeland Security, Customs and Border Protection, and the leadership of those organizations at the time this was going on, and USCIS. It was not against President Trump personally. So when that happens, when government agencies are sued, it's not really against a particular political administration, it's against the agency itself, which means that just because there's a change of administration, the lawsuit continues, and the new administration does have to decide, are they going to continue to defend the agencies that have been sued? Most times, a new administration will take a look at the lawsuit and say, well, what's being charged? Is there a principle under law or under what is called administrative agency privilege that the new administration wants to continue to defend? So, for example, if the case is charging that an agency doesn't have a certain set of authorities to do something, the new administration may say, yes, but we think we do. We may not agree with the policy, but we think these authorities exist. Then they may want to continue to defend that case in court so that they're protecting those authorities to be used in ways that they think maybe are better than the existing policy. Other times they look and say, this was a policy we don't want to associate ourselves with, so we will try to settle the suit, or maybe, withdraw their objection to the suit. That's rare, but usually they'll try to settle the suit. And that's kind of what happened in this case. Obviously, the Biden administration formally issued an executive order when it came into power in February of 2021, not only repudiating this policy of the Trump administration, but creating a new task force to reunify families, a provision for families to be reunified, and work together with the plaintiffs and the ACLU and other organizations to basically try to undo the harms that were done by this previous policy. So clearly they wanted to separate themselves from it. But, it took a long time because there were certain things, certain prerogatives that the government still wanted to preserve that may require in the future some form of prosecutions or separating a child from a parent when there are other issues at play that the government want to pursue. So it couldn't be a blanket, we will never do this again in any circumstance. And then it was a matter of what remedies could we provide the families that had been separated given the authorities they have under law. So the administration can't just say, we'll give you a green card. They don't really have the ability to do that, right? You have to get a green card. You have to qualify under one of the categories under law, things like that. But they could provide protection from deportation. They could maybe do a parole status, other things. So those were the terms of the settlement that they were negotiating. But as I said, even though this was clearly a Trump policy that the Biden administration did not agree with, those details in a legal settlement, which are binding on this administration and future administrations, meant that the Justice Department and the agencies wanted to be careful. They weren't essentially giving away things that they thought would terribly hamstring in the future. So to give you an example of a settlement that is still creating some issues, back in the Clinton administration, there was a lawsuit against the government on behalf of a minor named Flores, who sued the government for keeping that person in immigration detention for quite a long time. The government agreed to settle that case, and under the terms of that settlement, agreed that the government would never keep any minor in immigration custody, whether it's CBP or ICE, for any longer than 72 hours. During the Obama administration, a challenge was made under that settlement that dates back to Clinton era, that the detention of families with minor children violated the terms of that settlement agreement. And the judge in that case said, yes, it did. And you can't hold kids, even if they're with their parents, for more than 20 days. The Trump administration was bound by that. The Biden administration is bound by that. So these settlements, not, just like a court decision would be binding on all future administration, these settlements, because they are authorized by a court and overseen by a court, also bind future administration. So that's a big consideration when a settlement is agreed to.
So that's really interesting. And I'm curious if in those two cases you just mentioned under Obama and Clinton, if they had taken as much time as the Biden administration did to iron out those details, and if the Biden administration took as long as it did in order to prevent future incidents like that happening again.
Yeah, I think during the Clinton administration, the settlement talks did take into account what they thought they could foresee at that time. I don't think they foresaw the massive arrival of families at the border
Yeah.
that they saw under the Obama administration. And so, that was an unforeseen circumstance. They did the best they could at the time to say, we want to preserve certain authorities, but we agree to this. I think under the Obama administration, I mean, some of the attorneys that were involved in that case, where the judge said, hey, detention of families also falls under the settlement, did argue that the inability to detain families could result in more families arriving. And certainly we have seen that. And whether or not you agree that detaining families might be a deterrent for future families coming, um, it certainly is the case that the inability to detain any families for more than 20 days hurts the ability of the government to create expedited processes that have due process in them, say for asylum seekers. So it is creating challenges. There have been legislative attempts to overturn Flores by legislation. That is one means that can be done. Obviously, any given law could still result in a lawsuit if plaintiffs allege that the law violates the Constitution, but a change in the law would overturn any previous settlement agreement, which was based on previously existing laws. So, I think that it does create operational challenges. Sometimes it creates policy challenges. I think the Biden administration is doing what it can, given that it's seen how some of these past settlements are, constricting what it can do now, rightly or wrongly. You can have opinions on that, but it does constrict what they can do from a policy perspective now, and are trying to ensure, at least so far as they can foresee right now, that they can still manage the arrivals, that when they deem it is necessary to separate a child from a parent, say where the parent has another type of criminal charge against them, where the safety of the child is at stake, even where there is some doubt as to the relationship between a parent and child, they may temporarily separate. So I think these are the conditions under which they believe, hey, there's a rational reason why we might then separate a child from at least someone who claims to be a parent. They want to preserve some of those things. But in general, there would never be another blanket policy that would separate children from, that would result in the separation of children from parents, like there was under the Trump administration.
Yeah. You touched on this a little bit, but I want to dive more into the settlement itself. What exactly did the Biden administration agree to in that settlement?
So, as we said, the original lawsuit was filed on behalf of a particular woman. The court later agreed to make it a class action lawsuit, which just means that other people who had been put in similar circumstance to that original plaintiff, and there were actually several plaintiffs, could benefit from whatever court orders there were. The court did eventually put in place a preliminary injunction against the policy. That was a couple days after Trump himself decided to terminate the policies. But the settlement agrees on who is in the class that is eligible to benefit from the settlement. And it's both people that were in the class that the original court case applied to, but also it can apply to kind of future people who might be put in this circumstance, right? So there's sort of two sides to this. It provides that the government will not separate children from parents or legal guardians except in specific limited circumstances, as I mentioned, including where there's national security implications, where the safety of the child is a question, where there are medical emergencies. For example, a parent has a medical emergency and has to be rushed to the hospital and the child cannot go with them. Or if there are certain types of criminal warrants apply to the parent, where they could be prosecuted. It says that when that happens, there are specific procedures that have to be in place so that that parent and child can be reunited again. You'll remember that one of the big issues that was against the Trump administration that came out sort of after the policy ended and in subsequent case filings in court was that the Trump administration had no policy or process or even conceived of one to reunite these families that had been separated. And so it was a huge challenge because the parents were not informed where their children were placed. The children that were separated they didn't always tell Health and Human Services that they had been separated from a parent, so that there was even anybody to reunite them with. There wasn't good records kept, like all kinds of things. So that's one of the things that the settlement requires, is that anytime there is a separation, even under one of these limited circumstances, there is a process and procedure to reunite them, that the parents are made known what happens to their child, that they can communicate with the separated child, and when and how they reunify the family after the circumstances that require the separation are concluded. So basically ensuring, one, it won't happen on a blanket scale, but when it happens on an individualized scale, there's still ways that people can be reunited. The settlement also confirms that the government will continue to try to reunite those families that had been separated that have not yet been reunited. And court filings indicate that maybe as many as a couple thousand cases where they still have not been able to reunite. And they would extend parole to parents that are still trying to reunite with a child, and other family members related might be able to join them. So it's providing a way for parents to be in the United States. It also provides that those who are in the class that the settlement was agreed on that had been separated are entitled to some support services, including behavioral health services. Obviously, there's a lot of mental trauma that was associated with this for the parent and the child. So the government will provide those services for 3 years. They will provide medical assistance where needed, covering the costs for class members that are receiving medical services. They will provide temporary housing support for 12 months because parents that are still trying to reunite with their children may not be able to work or have not been able to work. They will provide legal legal services to help the parents and the children with immigration cases, including filing of asylum claims or other relief to which they may be available, expediting the processing of those claims, particularly asylum claims for people who have been separated. So those are the primary functions. The one thing that's not part of this is cash payments.
Yeah. Why is that?
So there are separate cases that are seeking essentially damages, monetary damages from the government for having done this. Those separate cases will be decided separately on an individual or a class action basis. That is not part of this settlement.
So, why is this lawsuit the first to reach the stage? As you mentioned, this is not the only lawsuit against the Biden administration or the administration for this policy, but it is the only one that's not seeking monetary compensation, it sounds like. So, why was this the first one to reach a settlement?
Well, as you said, like it's been 3 years, or almost 3 years into the Biden administration that the settlement has been reached. So, it's still, that may be relatively quick in court terms, but it's still taken quite a long time to get to this
Yeah.
point. I think the monetary damages issue is a separate issue, right? That's on a separate basis, right? So this particular case was based on the government's violation of the immigration laws and the Administrative Procedures Act, and to some extent, the Fifth Amendment rights of the those who are prosecuted criminally. This lawsuit is about, did the government violate its own laws or the processes by which it can implement new policies? Monetary damages comes when you say that beyond violating its own laws and policies, the government did actual harm to somebody and they're entitled to recompense. That's a different type of case. There's something called the Federal Tort Claims Act that applies when the government is accused of doing actual harm and somebody is entitled to remuneration for that harm. the settlement here was aimed primarily at getting the government to meet its legal obligations under the Immigration Act, and to not enforce a policy that would violate that. So the child separation policy, the zero tolerance policy, the prosecutions that led to this, right? It's aimed at getting the government to sort of change what it does and how it does things. And to the extent that its failure to do that in the first place resulted in individuals not receiving the legal things they're entitled to under those laws, like the ability to apply for asylum and the ability of their family to be together, it's asking for those kinds of things under immigration law and legal supports. The cash remuneration is basically a penalty against the government for having done that. And so that has to be considered separately. I think that's in a separate set of court cases. And, the government may or may not agree to settle for that in that case. But since that involves payments that have to be authorized essentially by Congress to settle those kinds of claims, it's a little more complicated than these. It's not that these agreed upon things don't have a monetary cost to the government. They do, but theoretically, these are costs that can come under existing appropriations categories for the migrants or their families, whereas the kind of monetary settlement may not. And there were press reports a year or so ago, or more than a year or so ago, that the government was entertaining cash remuneration or monetary damages settlements, and that created some political blowback for the administration. I think that Republicans said, that frankly, in their words, illegal immigrants should not be entitled to damages, monetary damages from the government. There are others that say if they were harmed, certainly they do. Otherwise, how do we make them whole? So this is somewhere in between those two things. I think the latter piece will still have to see what the court decides, if the court awards it, or if the government decides to enter into settlement talks there. If you recall, when those reports came out, the Biden administration was quick to say we are not engaged in those kind of settlement talks. So it may be that they're continuing to defend against that because, again, there may be a principle there in which saying that even though the federal government did something that hurt you, that if it doesn't necessarily mean that you're entitled to that kind of monetary damages. So again, going back to how we started this conversation, it may be a principle that the Biden administration is trying to defend against there rather than the policy conversation.
Yeah, it'll be interesting to see how those other cases play out. And I imagine, given the length of the one we've been discussing, that the outcome might take some time for us to...
Who knows? It may stretch into another administration.
Yeah, we'll just have to wait and see.
Yeah.
Well, Theresa, thank you so much for joining us today. To our listeners, we'll see you next time on This Week in Immigration. One last reminder to subscribe, rate, and review this podcast on Apple Podcasts, Spotify, or your favorite podcast platform, and share it with your friends and colleagues. You can also find more information on all of the issues we discuss here on the show at bipartisanpolicy.org/immigration. You can follow the Bipartisan Policy Center on Twitter at BPC_bipartisan. You can follow Theresa Cardinal Brown at BPC_T Brown. Send your comments and feedback to us at immigration@bipartisanpolicy.org. I'm Hanadi Jordan. This Week in Immigration was created and executive produced by Theresa Cardinal Brown. This week's episode was written by Emily Vasquez, Hanadi Jordan, and Theresa Cardinal Brown. Joshua Joe is our audio editor. The executive producer of BPC Podcasts is Lucy Manning. See you next time on This Week in Immigration.